Hello everybody, this is Seth Weissman and welcome to another episode of Safe Real Estate. Today we are going to talk about a recent Court of Appeals decision where the court basically affirmed the notion that if you want a client relationship with someone, you better have a written agreement. And actually it's a fairly interesting fact pattern because what happened is the broker had a written listing agreement with the seller, which then expired. And several weeks after the listing expired, an offer came in. The former listing broker got involved in the transaction and handled it through the closing. But there was no reaffirmation or amendment of the original listing agreement. So technically, the listing broker was not representing the seller. But the listing broker handled the transaction, got paid a commission, and as luck would have it, the seller became disgruntled with the amount of money that the seller was receiving. And like all disgruntled sellers, the seller quickly focused on the broker and said, I'm going to sue you because you should have given me better advice than you did. It resulted in litigation which went all the way up to the Court of Appeals. And the broker, one of the broker's defenses was, hey, I was not even representing you subsequent to the listing terminating. I was working with you, but you were only at that point my customer. And interestingly, the Court of Appeals agreed. The Court of Appeals said there was no written agreement, therefore you had a customer relationship established, not a client relationship, and as a result, the duty which was owed to the seller was a much lower duty than might have been the case had it been a client relationship. So the rule of thumb should be, if you want to have a client relationship with someone, you better get a written agreement in which that relationship is established. As always, it's great to see everybody. I hope you liked that little episode. Please continue to tune in. Thanks so much. Bye now.